Good afternoon, everybody. Thank you for joining us today. Today we're going to be talking about violations, and we have attorney Chris Gelwicks presenting. So before we get started, a couple of reminders. We are in our 30th year, so we are doing a celebration to celebrate our 30 years of being CAMS. So part of our 30th year, we're doing a giveaway. So last month's giveaway was Bob Howard with Cleveland Place in Greenville, South Carolina. So congratulations, Bob. Bob won a $100 gift certificate or an Amazon gift card. And at the end of today's call, we will be doing another $100 drawing. So we do thank you again for joining. So as a reminder, we will be doing Q&A. Please use the Q&A option at the bottom of the screen, and you can ask a number of questions, and we are anticipating several. So please feel free to ask questions, and we do have individuals moderating our Q&A for the two presenters. And finally, I totally forgot what I was going to say. So, but Chris, I will turn it over to you. We will get started, and thank you again for joining us.
Sure thing. Yeah, thanks, Ben. Again, folks, my name's Chris Gelwicks. Hope I'm seeing some of the names of the participants, recognize a lot of you. Those of you who have heard me speak before, welcome back. For those of you who haven't, I just want to give a brief introduction to who I am and how I approach HOA law. I've been practicing 25 years now. You could tell from the gray hair, I'm not a young attorney anymore. And I've been doing HOA law as the focal point of my practice for over 10 years. I bring with me in my experience a prosecutor and defense attorney background and a civil litigation background. And so I look at things like problem solving from a perspective of what do we do to keep ourselves out of court, because you know, my experience with court is it's expensive, time consuming, and HOAs who are have a budget don't really want to get involved with that. And that's certainly, no one wants to go to court. Even if they have to, they really don't. So my perspective is, how do we avoid getting there? And when I was asked to put together this seminar, just a quick story from when I first started doing this, it was preached to me by my mentor that you always want to walk into court wearing the whitest hat as possible. And so, Ben, you can scroll through the slides real quick to the picture of Mr. John Wayne there when it comes up. The white hat when it comes to HOA law means being the person, being the side that appears reasonable, being the side in the right. And there's a picture of John Wayne, Duke. For those of you who are too young to know who he was, he's the famous Western cowboy actor. And you can look, he's wearing a white hat there. He's got the guns, he's the sheriff, but that white hat is crusty, beat up, but it's still white. And many times when we're dealing with violations, we're dealing with people who have done something that is in violation of the restrictive covenants or our rules and regulations. And in doing so, we as board members, and I say we because I am on my HOA board, in a momentary lack of reason, I agreed to be on it. So I've sat on your side of the table, and when these things come up, we sit and decide what we're going to do to the person or people who are in violation. And however we do it, whatever we do with that, we want to make sure that we are acting reasonably. And I'll explain why in a few minutes. So, and as board members, when it comes to dealing with violations, we have dual roles. Ben, you can advance that. We wear two roles at a minimum. You can see the guy on the right there, that's me. Obviously on the left, that's TJ Hooker cast. That's from my childhood. But as a board takes on the role of a policeman when we come to restrictions. And as policemen, we are charged with enforcing our restrictions uniformly. We take on that role. We have a fiduciary duty to do that. We have a fiduciary duty to make sure the restrictions are enforced, that the members are following them. You want to continue, Ben? The other role we carry in this is as a lawyer, and that's why you have my picture up there. As a lawyer, we need to know what our documents, how they read. And I have examples here of, have your lawyer on speed dial, obviously, if you have a question about what something means. And examples of that are, quorum, notice amendment, but also what the use restrictions and generally what restrictions, what powers we have. And many times that's in the documents, but sometimes it's not. So why do we want to wear the white hat? What's the issue for us in getting these things enforced? Well, generally in North Carolina and South Carolina, the courts there will strictly construe restrictions and will, whenever possible, lean their decision in favor of the unrestrained use of property. What does that mean? That means that we as homeowners associations are under constant scrutiny from the public, from our members. As board members, the members of our association believe that we answer to them, and we do. And so they monitor what we do. They will take note of where we are at various times. My association sometimes thinks that I have the time to drive through the neighborhood and look for high grass, for example. And of course I don't. But we are presumed to wear the black hat going into court. We are presumed to be the ones that are unreasonable. And that is the mindset of both North and South Carolina courts. And how do we get around that? Well, we have two options. We can change the mindset. The only way we're going to change that mindset, folks, is over time with favorable court decisions if we get there. But until the mindset, until that ever changes, we win them over with reasonability. We document what we do. We show and exhibit. We exhibit ourselves with and give the courts a history of reasonability with any case that comes in front of them. We show uniformity of enforcement. We be specific with our violation language, and please not be petty. We don't be petty in what we do. So we look at all of this. We come at it from the perspective of we need to make sure the court looks at us in the most favorable light. And so what this seminar, hopefully we're going to talk about, hopefully you'll get something out of is, how do we walk in having done everything we can do to wear the white hat and get the best result possible if we ever get to court. And if we do things the right way, we hopefully won't ever get there. Hopefully we will be able to deal with violations. If we act reasonably on the front end, they never go past the hearing stage at most. So next, if we go to the next slide, the issue of violations in both states, in North and South Carolina, there's two differing governing areas here. One is statutory. North Carolina, for those of you I'm sure understand, who have been on boards for a while, we have the North Carolina Planned Community Act and the North Carolina Condominium Act. We also have statutes, other statutes like the Nonprofit Act, which is in both states, North and South Carolina. There are various other statutes, for example, the solar panel statute, the transfer fee statute. There's others besides the acts, but the acts are the main ones. We also have, of course, for authority for enforcement, our restrictions, our declaration of covenants, our declaration of condominium. In South Carolina, for condominiums, you have what's called a master deed. We also have rules and regulations. Now, many problems with enforcement arise from the enforcement of rules and regulations. And so we're going to talk a little bit about those later. We also have guidelines, architectural guidelines. Policies that govern how things happen interior with the board. So all of those things play together. And so let me go back then to the statute part of this. As I indicated, in North Carolina, we have 47F and 47C. Specifically, those code sections are 47F and C 3-102 and 3-107.1. 102 if you've ever read it, lists the powers of of a homeowners association or a condominium, and they are broad. It is written broadly because if they did not write them broadly, they would always, that statute would go on forever. 3107, as many of you know, is our hearing requirement statute, and we'll get into the specifics of that a little later. For South Carolina, there is no statute, and you see the picture of cowboy there. It's termed down there to be the Wild West. There was a movement a couple of years ago to pass a South Carolina HOA statute that mirrored the North Carolina statute. That didn't pass. There was some statute passed, and specifically for South Carolina, there was a requirement passed that as of January 11th, I think, 2019, rules and regulations, if you wish to enforce them, you've got to record them. Same way with bylaws. So why is that important? Well, in South Carolina, your authority to take remedial action against someone who is in violation of the restrictions is totally document driven. Unlike in North Carolina, where you have the authority under the statutes, in South Carolina, you have no such authority. So if you have no authority to have a hearing, for example, and find someone in your documents in South Carolina, you cannot take that remedial action. Let's go to the next slide. So why are we doing this? We sit as a board of directors. Someone comes and complains that an owner's fence is not in the right location. Someone complains that trash cans are observed out at the wrong time. Someone is not maintaining their grass. What is our goal with these violations? What's our purpose? And I'm going to throw out about 5 different words here, and we'll go through each one and discuss them. The first one is our purpose to punish? It's not. Our purpose is not punishment. We are not the police. We are not a court of law. We're not a criminal court. Punishing someone in some fashion because they left a trash can out at the wrong time is not our role. Is it money? Do we want to levy fines and collect money so we have money in the coffers to do other things and improve our amenities, whatever? No, that's not the purpose of this. That's why we have assessments. Our purpose is not to pad the association bank account by issuing fines. How about to set an example? This is where you get into selective enforcement. Setting an example of a person, a person whose grass is too high, a person who parks their boat in the wrong location, a person who parks on the street. Setting an example by fining them, by suspending their privileges. That's not the reason. Certainly not publishing to the membership that these people are in violation either. That would be a very poor way to set an example, and it would get you potentially sued. How about to embarrass? Well, of course not. We're not here to embarrass anybody, okay? A violation of a restriction does not warrant public shaming, despite what some people may think. And I will give you an example of something I heard, and that's actually in a video that you'll see in a little bit about that very thing about embarrassing someone. How about revenge? Personal problems between with board members and members specifically regarding the violation. Are we there to exact revenge? No, we're not. This isn't a torture rack. Okay, that is a picture of a torture rack, by the way. This isn't that. What is our goal? Our goal is to gain compliance. Our goal is to get the individual who is in violation, to have them stop the activity, to correct the problem, to do it quickly, so that we can continue to then move on with our lives, knowing that they're complying with the restrictions and everybody's happy. All right. So how do we do that effectively and reasonably? You can go to the next slide, Ben. By the way, Pepper, there's one other of these. The first thing that kept up on the screen is a fun fact. has nothing to do with HOA law, but in case you are ever wondering, if you steal over $1,000 worth of grease in North Carolina and are caught by the police, you could be charged with a Class H felony. There's your statute reference. It has no bearing on HOA law, but I thought it funny because I'm sure people are going around stealing thousands of dollars worth of grease. For North Carolina, and this slide, we really need to read in conjunction with the next slide, but we'll go through this real quick. Procedurally in North Carolina, for South Carolina people, you should still pay attention to this because you'll see in the next slide how we link these together. North Carolina, the procedure for a violation hearing is set forth in 47F and 47C 3-107.1. Now, the introductory language of that statute reads that if your documents have a different procedure in them, then you can follow that procedure and not do the one in the statute. I will tell you that I have read probably thousands of sets of restrictions at this point in my career. I have probably seen 20 different procedures at most within the documents. Most restrictions do not contain a specific procedure. I have seen them in South Carolina more than I've seen them in North Carolina, which is good. So rarely will I see a different procedure. Generally, I see a different procedure in the following context. There will be a procedure where it is an owner is alerted to a violation, that they are given a set time to cure it in a letter from the association. And if they do not cure within that time frame, then a fine will then ensue or a suspension will then ensue. And if an owner wishes to have their appeal heard on that violation, they then need to request that the board hear them. That is really the only alternative procedure I've seen. Whether that type of procedure would stand judicial muster has not been tested to my knowledge. My opinion, and this is a personal legal opinion based upon my experience, is it is always better when you're dealing with a violation of your restrictions to have a hearing before you take remedial action. In North Carolina, the statute prefers that. And the reason I say it prefers that is because it sets forth that specific procedure. Before you can take remedial action, you provide a notice and an opportunity to be heard. What does that mean? You tell the individual you have a violation hearing coming up at a set date, set time. You have an opportunity to be there and explain why you shouldn't be found a violation. Now that hearing that will be held can be held before the board, or if the board chooses, it can appoint what's called an adjudicatory panel. Now I've had the question, do we have to call that an adjudicatory panel? No, you don't. You can call it whatever you want. The key to such an adjudicatory panel is it is appointed by the board and it must not have board members on it. And the reasoning behind that is because the statute allows owners who don't like the adjudicatory panel decision to appeal to the board. So it really wouldn't be fair if a board member sits on that panel who then will also hear the appeal. So that's why board members cannot be on such panel. People have asked me, members have asked me, do I recommend adjudicatory panels? Recommend is not the word I use. I'm not opposed to them because the statute allows them. But my thinking on this is if the owner has a right to appeal the panel decision anyway, why not sidestep that and just get them in front of the board? My personal opinion, certainly I have associations that use the panel system and it works for them and that's great. At the end of such hearing, the board can then make a determination that a fine should be imposed with a maximum of $100 for each violation. So if the person is in front of the board on 2 or 3 violations, let's say 3, you can fine them $100 if they are in violation for each one. Further, and this is where we get a lot of questions, and this has not been judicially tested because I think the statutory language is pretty clear, is that without the need for further hearing, you can fine for each day more than 5 days after the decision that the violation occurs. That means if the hearing is today and the decision is issued today that you are levying a fine for something of up to $100, you have to give them basically at least 5 days to cure. If they cure it in that 5 days, then the fining must cease. If after 5 days, the violation is not cured, and again, that is a minimum of 5 days. You can give them longer. And I'm going to talk about why you may want to a little later. But you give them 5 days to cure it. If they don't cure it on day 6, you can start fining or suspend the privileges. The suspension itself can be continued without a further hearing until the violation is cured. That's the procedure in North Carolina. South Carolina, there is none. But I submit to you that courts, and you'll see this in the next slide, courts love due process. And so, if you go to the next slide, Ben. You know, we just talked about the hearing process. What can you do if someone is in violation? The first thing you can do is nothing. And there's the case I cited there, McCraw versus O. That was an architectural review issue. The owners in the association noted to the board that there was a violation. I believe it was a fence, but I don't remember, and that's not really that relevant about what it was. There was an architectural review. The board decided to not take action. Neither did the architectural review committee. The members of the association brought a lawsuit. They named the owners who were in violation. They did not name the members of the ARC committee. And they did not name, to my knowledge, the board, but they should have if they didn't. That case stands for the proposition. It reinforces the proposition that owners can bring actions against other owners for enforcement. That is well-established law in both states. It does not have to be the association that takes action. Now, please don't take that for me to say that the association should never take action. That's not what I'm saying. What I am saying is, whatever the association does in a case of a violation, each owner that is subject to those restrictions may bring a lawsuit against the offending owner to enforce. So keep that in mind, especially when you get in a situation where you've got owners who are complaining about something that probably is not an HOA issue. For an example could be lights shining in the backyard and it's bothering a neighbor. That's probably, please don't hold me to in every circumstance of this, but that's probably not an HOA issue. And if it's not an HOA issue, I have advised my clients many times to send correspondence to the complaining owner that this is not something we can get involved in, but you have the right under the law to bring an action to enforce the restrictions if you feel that strong about it. Almost every time that has happened, the owners choose not to take any action and the matter resolves. So what's the second thing you do? Well, you can sue them. In North Carolina and South Carolina, you can seek injunctive relief to have the violation cured. If you bring an action in North Carolina and your documents have language in there about the recovery of attorney's fees in an enforcement action under the Planned Community Act and in the North Carolina Condominium Act, you can potentially recover the attorney fees spent in getting a judge to issue an injunction to enforce the restrictions. It is not a guarantee. Judges in both states do not enjoy awarding attorney's fees in cases. Maybe they don't like attorneys. I don't know why. All judges are. Nevertheless, they're not favored. So I say you can request them, but the idea of seeking injunctive relief is there. And in some cases, and I will give you a personal one as an example, it is really the only way that you're going to get any sort of resolution. The personal, for my part, is in my association had in it, and give me about 2 minutes to go through this. My association has a leasing restriction that all lots must be leased for no less than 6 months at a time. We had an owner that was running a VRBO out of her home. It was being rented 2 days, 3 days at a time through VRBO. We had a hearing. The owner failed to show up. We met with association counsel, which was not me because I'm on the board. And we determined that a fine in this case probably wouldn't do anything because of the amount of money that the owner was collecting when they rented the property. This was being rented sometimes at $10,000 a weekend. It's a nice property, it's a nice house, and it's on the lake. So, and people were paying it. And so it was determined that our best option was to bring a lawsuit seeking injunctive relief. And that's what we did. And after about a year or so of litigating the matter through motions and some depositions, the matter actually settled. It settled because she sold her house, but she also had to pay back some of the attorney's fees as part of the settlement. And we also got from that owner a sworn statement that we were correct. It's not as good as a judicial decision, but we felt good about how we pursued that. We believe we upheld the membership's interest in that. So that's just an example of seeking injunctive relief. We were seeking a court order to stop her from renting her unit like that. So just an example. Self-help, if allowed in the documents. Now, what do I mean by self-help? A property has, I've seen this example, a house has mold growing on the side of it, green mold, the owners won't respond. A lot is not being maintained, the grass is not being cut, it's getting knee high. Many, if not most, of the restrictive covenants that I read have a provision in there, but again, both North and South Carolina, that the association has the right to enter upon a property and cure a violation and assess the cost incurred by the association in curing that violation back to the owner. Almost every set of documents that I see nowadays has those. Many, and I would say most overall do. I have a little caveat there, not authorized by me. I will never, I should never say never. I have never given a legal opinion to a client of mine that says, yes, you can go in and cure the violation. To me, I think that opens the door to potential harm to those going on the property if it is not abandoned. Potential liability if something is damaged or otherwise happens while the board's agents are on the property. There was an example of a number of years back about an association taking remedial action by going on a property and cutting grass. The contractor cut the owner's prized tomato plants, and the owner sued the association and got money out of it. We don't want that to happen. Are there cases where it could be appropriate for the association to employ self-help? In emergency situations, condominium boards do this. You've got a leak coming out of a unit, potentially even a fire. That can be warranted, absolutely. But as a general rule, even if it's allowed, I discourage the practice. Many of my clients hear me discourage it and then take their action that they want to take. And it is what it is, and I understand why they do that. And being on a board myself, I certainly understand that. I understand that reason. So if we could go to the next one. In North Carolina, and if in the governing documents, also South Carolina, you can find, again, after notice and hearing, we already went through that, or if there's another process in the documents. Now, one of the keys, of course, is, well, if they don't pay the fine, what do we do? Well, in North Carolina and in South Carolina, if it's written in the documents correctly, you can actually foreclose on the property if the fine is not paid. Now, I say judicially foreclose in the slide, and there's a reason for that. In North Carolina, if someone is delinquent on their assessments, you may proceed to foreclosure through what's called the power of sale process. Power of sale process is an expedited process in North Carolina, where you simply file a notice of hearing. You show up at the day of the hearing, you present some documents to the clerk of court, and they look at 4 very specific items, and 99% of the time, let's say 90% of the time, the order is signed, and we could potentially sell the property within 21 days. Very quick process. That's not the process in South Carolina. South Carolina, you have to file a complaint and actually go through the full lawsuit. They get 30 days to answer. If they answer, it's going to go into discovery and it can drag on for a long time. In North Carolina, to collect to foreclose for allowing payment of fines, it's the same process as South Carolina. You have to file a complaint, and you have to go through the whole lawsuit process. Likewise, in North Carolina, and it's the documents allow in South Carolina, you can suspend the privileges and services, and I say even water. I have one association right now, Townhome Association, that if someone is in violation, they could hold a hearing and cut off the water. They don't normally do that. They only do that for non-payment of assessments. But the language in the statute allows you to suspend privileges and services provided by the association. If water is a service provided by the association, technically speaking, you could shut off that water. After notice and hearing, of course, or other process that it's in the documents. Now, does that mean you're being reasonable if you do that? Different issue. Understand, and this goes back to what I said before, courts in both North and South Carolina disfavor restrictions. They like people to be able to use their property unrestricted if possible. If you're going to restrict someone's ability to use the pool, for example, or if you're going to fine someone, courts are going to require that you have followed some sort of due process before you take such action, which is why I recommend having a pre-fine hearing or pre-suspension hearing, even if your documents allow for something else. It makes you look reasonable. And again, we can cover a lot of ground with the court if we walk in showing a history of having a hearing, giving notice, talking with the owner, sending violation letters prior to having the hearing, talking with the owner after, asking them to comply even if they don't. We earn goodwill and we appear to wear the white hat. It just makes sense. It's common sense. If we're going to go, if any member of this, if nothing else coming out of this, anything you do, you need to understand, you need to be able to look forward and say, what happens if this goes to court? Am I doing the thing that is going to make us look best if we go to court? So,
Chris,
Ben, you popped up there.
I did pop in. So a couple of questions have come in, and I remembered the one thing I was going to say because we always get a question about it. So we will make this recording available. It does live on our website, the CAMSMGT.com website under the board members section. So you can find all of the webinars that we've hosted under the board members section. And so this will probably be posted by Monday. So if you have any other board members that are interested in viewing this, they can click on that most likely Monday morning. So questions. So we have two precedent related questions that have come in, and I know you're going to talk about precedent. So I'm going to skip those questions until maybe the end. First question, as a board member, is there a duty to report violations? Live in a small condominium association. I see violations that will certainly be an issue. Do we have to be involved?
That's an excellent question. As a board member, you have a fiduciary duty to make sure the restrictions are being enforced. Now, when you say report, who are you reporting it to? You're going to report it to the remaining board. You're going to report it to your management company. Hopefully you have a process in place where if a suspected violation is reported, management company sends out a letter, stop it, correct the behavior, move on, and that'll be the end of it. But in the end, if you report it, you're going to report it to your board members, and the board members, you and the board members will decide what action to take. Understand your fiduciary duty. Your fiduciary duty is to, you have a number of them, and this is not an exhaustive list. But you have a duty to collect assessments. You have a duty to enforce the restrictions. You have a duty to now under the FHA, if a discrimination is reported to you, the issue is reported, you have a duty to take some action there. That fiduciary duty runs whether you are simply an owner observing something or where you're wearing your board hat. So do you have a duty to report it? Yes. Different issue though, and hopefully you'll see later on in this, depending upon the violation, the remedial action you take can vary depending upon what's going on. So bear with me, and if at the end of this you still have that question, we'll revisit.
Okay, for South Carolina, you stated that the governing documents do not specifically authorize or state that fines may be issued for violations. Then such action cannot be taken. Is that overridden in the rules and regulations, or is a fine policy established, adopted, and recorded? What do you suggest?
Okay, let me clarify and just make sure we understand here. If the restrictions do not contain a fine process, the restrictions do not contain the ability for the authority for a board to fine for violations, and I'm going to tell you, you can't do it. The idea, the concept of, well, can we put in a rule and regulation and then record it? Here's the distinction. Rules and regulations are passed by the board, adopted by the board, published to the membership, and then recorded in South Carolina because they have to be enforced. That is different than putting something to a vote of the membership where you're amending the declaration of covenants to add a fine procedure into those restrictions, and then the members approve it by 67% or whatever, 51%, whatever your covenants require. Big difference. And the big distinction here is one is board action only, the other is member action. In my opinion, now in South Carolina, I understand the procedure for adopting rules is you have to publish them to the membership and then record. You can offer a debate and everything, but that's still different to me, in my opinion, than proposing an amendment to your restrictions, taking it to the membership and saying, okay, members, we want to be able to fine people so we don't have to sue everybody that's in violation. And the members vote yes or no. If they vote yes and you record it, I'd say you're good to go, obviously, because it's in the restrictions. If you don't, I do not believe you can cure that simply by making a rule and then recording it. I hope that answers the question.
So in North Carolina, you commented on $100 per offense, or was it $100 per day?
Both. $100 per offense per day. If I'm in violation of building and having an above ground pool, parking on the street, and trash cans, that being out in the street after pickup in violation of the restrictions, that's 3 offenses. That's 3 violations. Maximum for each violation is $100. So I could potentially be fined after the hearing $300. If I don't cure those after 5 days, I can then be fined $100 per offense per violation, so $300 per day until each one is cured. If I cure one and not the other 2, it would be $200 per day, etc.
So are rules and regulations treated the same way regarding enforcement as your covenants?
No. And the distinction there is, are you talking procedurally, or are you talking substantive? In North Carolina, and again in South Carolina, if your documents allow, you have the right to draft and adopt rules and regulations. Many declarations of covenants have the ability in there for the board to adopt rules and regulations over lots. The distinction, though, is the rule and regulation making something more restrictive to an owner than what is in the restrictions. If it is, a court will definitely overturn it. If you are adopting a rule that lightens a restriction, I think you have a different issue there in that you're breaching your fiduciary duty, because the restrictions have in them a set, you have to set standards you have to follow. To make it less restrictive is really a violation of the covenants in and of itself. On the other hand, rules that define a process of how things work, that's perfectly appropriate, as long as it's not in conflict with the restrictions. Rules that complement the restrictions are fine. Rules that conflict will be unenforceable.
Okay, what obligation does the HOA have to have accurate HOA rules and documents publicly posted?
None. There is no obligation to post your rules, your restrictions, bylaws on a website. There is no statutory requirement anywhere. However, 55A, the North Carolina Planned Community Act, and 33, South Carolina Code 33-31 something, both is the South Carolina Nonprofit Corporation Act. Both of those have a section with 16 in it. It's 1601 in North Carolina, and it's 33-31-16 in South Carolina. Require corporations to keep their bylaws and other sorts of governing documents on hand and to be available upon request. And in North Carolina, both acts require records to be turned over certain records to be turned over upon request. So the idea is, no, you don't have to post them on a website or even provide them to someone at closing. You're not even required to do that. I'm sure that question was coming. Is it good to do that? Yes. Can it save you time and aggravation later when someone says, I didn't get a copy? Well, if you put it on a website, you can say, well, look there. And if there is a way to show they got them at closing, you can say they had them there. So it's not required, but it is a time saver and an aggravation.
So I'll do two more questions and then we'll get back. But for North Carolina, if an alternate procedure is adopted, but the fines at any step is greater than $100, is the greater fine still enforceable?
In my opinion, no. The language is pretty clear that the maximum, and this is under 47F and 47C 3-102, subsection 12, might be 11. I don't have the statute in front of me, but it's one of those two. Limits it to $100. 47F 3107.1 says a maximum of $100. While the process may be different, if it's in your documents, the maximum fine is $100. And understand too, simply because you can fine up to $100 doesn't mean you should, depending upon the violation.
So the follow-up question to that one, in North Carolina, older communities that are pre-statutory or 1999 that may say $150 or greater, is the $150 enforceable?
No, it's not. In North Carolina Planned Community Act, applicability section is 47F 1-102. It indicates that, and same way with the Condo Act, it indicates that 47F 3-102 and 3-107, again, the powers of the association and the hearing process are, for lack of a better word, and I don't like this word, but they're grandfathered to all associations. In other words, they apply to all associations regardless of your formation date. So the cap of $100 applies to everybody, doesn't matter when you were formed. As does the requirement of due process, unless your documents indicate otherwise, then you have to follow what's the process in 47C and F 3-107.
Okay. Well, Chris, do you want to give a little intro to your videos?
Yeah, we had a little fun with this presentation. You're about to watch what I would term a mock hearing. Please turn your volumes up. We don't know how great the audio is. Yours truly is in this one. If you saw the ones we did at the last one, I was not in those. I am in this one. There's will be one following this a few slides later. So I hope you like it. I think it's hysterical. So take it away. I'm getting tired of these hearings, aren't you guys? These people come in here, they're in violation, and all they do is make excuses. Oh, hi, I didn't see you come in, sit down. Are you Callan?
Yes, I am.
Are you the owner of lot 2267?
Yes, I am.
Okay, you're here for a hearing with the Stone Rock Hillcrest Farm Pond Homeowner Association Inc. You understand that?
Yes.
All right. Now you stand accused of violating the Declaration of Covenants and Conditions and Restrictions.
Specifically, by not pulling your trash cans in after pickup and by allowing your grass to grow higher than 2.6 inches above the ground. Do you understand that?
Yes, and I would like a chance to explain what happened.
Yeah, you'll get your chance. I just wanted to let you know what the parameters are for what we're doing here today. To my right is Ms. Farrell. She is a board member. To my left is Mr. Kim. He is a board member. Okay?
Okay,
All right,
yes, and I would like to explain what happened.
You'll get your chance. Okay? Let me get the rules out. All right? Don't be impatient. Now, we do these hearings. It's our role as a board to sit in these hearings, and basically we're the judge, jury, and executioner in all of this. You understand?
Yes, and
I say
really,
fryer, those cans are open.
You said it.
wow, you really are acting like a lawyer.
Is that a joke?
No.
I am a lawyer. Is that a joke?
No, I understand your rules. It seems like you're taking this pretty seriously.
Well, this is serious business. We can fine you up to $100 per violation per day until it's cured, and we can suspend your privileges.
Oh, wow, okay, yes, I understand. I just really want an opportunity to explain what happened.
Okay.
We were visiting my mother in the hospital.
Did you leave trash cans out overnight?
Yes, I did.
So you admit it?
Well, yes, I do admit it, as I
Okay,
said.
what about the knee-high grass?
Well, it wasn't knee-high, and we were out of town attending my.
I don't think we need to hear anything else.
Well, it was an unplanned trip, and when we got back, we cut it immediately and pulled the trash cans inside. And by the way, where does it even say in the restrictions that the grass can't be that tall? And who
Objection.
measures that?
Sustained.
Objection?
Overruled.
No, I wasn't objecting, I was restating.
I understand what you're saying now. I see how this is gonna go. You're gonna try and use words against us.
No, I'm not.
No, you're not. That's exactly what you're doing. I don't think we need to hear anything else. What do you think, Ms. Farrell?
Fine her to the max and take her pull fob. I drove by her house looking for violations
What?
the day that she left her cans out, and I was shocked and offended.
That's crazy.
Mr. Kim?
We live in an association that has rules, and if we don't police those rules, who is going to do it? You, Mrs. Garib? I still say fryer.
I think we're done here. You'll be getting our decision in writing.
Do you really think this warrants a fine? It was one time, and it hasn't happened since, and it never happened before. I've looked at the covenants, as I said, and I really don't see anything about grass height, so I don't think that's fair.
You already said that. We understand your position. Thank you. You can leave.
We take our jobs very seriously here.
Clearly.
Yeah, we're done.
Fryer.
You can go.
Okay.
That'll teach him.
Okay. So I hope you all laughed at that. That was a little over the top hearing. I will tell you that I've been in at least 2 hearings where it was about like that. And I was not the one, I was not playing the aggressor in those. I was observing a client and how they conducted their meetings. So what do we just see? Was it aggressive? Of course it was. Over the top aggressive. Was it forceful? Yes. And forceful to the point of being abusive, I would say. The board was unwilling to listen to the owner. And in the end, the goal of that hearing was not compliance. It was obviously to punish, especially in the sense that it was clear that the violations had already been cured. And yet the board, you heard the words fry her, finer than an axe. It's that type of thing that gives homeowner associations a bad name, because think about this. I always like making this reference. You can finish that slide, Ben. I always like making this reference. I'm a big Seinfeld fan. And in one of the early seasons, Jerry Seinfeld's parents moved to Florida, and Jerry went down to visit them. And they were having a discussion about condominium rules and the heat. And Jerry makes a statement that, don't you understand? I think he's talking to Elaine. That all these people do is they live to come down here, sit in the heat, and enforce these rules. That mentality is what we are up against. That mock hearing you just saw is really the perception out there of many people. How do we change that perception? By, well, we need to appear reasonable. How do we do that? How do we appear more reasonable when we deal with violations? The first thing we do is you adopt a violation policy. What do I mean by a violation policy? The policy can have a lot of things in it. Do we take verbal or written complaints from other owners? Do we do drive-through checks with managers? I know many management companies do that. And there's nothing wrong with that. That is, again, what the board is left with. We have a fiduciary duty to enforce the restrictions. We also have the duty, in my opinion, to be reasonable in how we enforce. But we can't enforce something we don't know it's there. So is it appropriate? It is appropriate to have drive-through compliance checks. I think it is. What about warning letters? How many do we send? Do we send 1, 2, 3? We're going to talk about that very briefly on another slide because moving on violations when they occur, you'll see why it is important to take action when you can. If we decide to fine, what's the fine going to be? I say, what is the fine schedule? Does leaving a trash can out overnight one time warrant a $100 fine? I can't answer that. It seems a bit excessive, but each case is different. But the key there is, do we as a board, now this isn't necessarily something you want to publish to the membership, but do we as a board have a set of parameters and a set of certain things, certain violations warrant certain fines or suspensions and others do not? How long do we suspend privileges and what privileges do we suspend? If you've got key fobs for your tennis courts and pool and things, do we suspend some or all of access to all of those? When you adopt and one thing about a violation policy, not necessarily the fine schedules or things like that. We'll talk about that in a second. But if you have a policy that you're adopting about violations, such as if we get a report of a violation, we investigate, we will send you a warning letter. If the violation is not cured, we'll send you a second. After that, we go to hearing. Sending out something like that lets the membership know what the board's standards are, what the procedure is, so that no one can question it later. Adopting a policy does no good if no one knows about it. And so publishing that policy to the membership, in my opinion, is a good thing. It also, frankly, is a check on the board because we want to make sure that we stick to the policy. It does no good to adopt one if no one knows about it. It also does no good to adopt one if we don't stick to it and follow it. And why must we stick to the policy and stick to the procedures? Because that shows uniformity. And if we are uniform in our procedures, key there is procedures. If we're uniform in our procedures, we're going to look reasonable. It's a lot easier for me to defend an association that has a policy of sending 2 warning letters, then it has a hearing, and then they fine according to the standards that they set, as opposed to in the evidence being presented that in one case they sent 2 warning letters and in the next one they didn't do any. It's just easier to defend. Hold the hearing and meeting if possible before you take any action, and don't be confrontational unless absolutely necessary. And listen, folks, being on the board, my board, I've seen confrontational hearings. Owners come in with an attitude. I get it. I've sat in meetings as an attorney advising the board where owners come in with 20 witnesses. It's imperative that you at least listen to the owner's story, and they may be combative, and they may ask questions about why they're enforcing it here and not other places. It's still imperative to give them at least the opportunity to be heard until it's time to shut it down. If they get abusive, if they go way off topic, different issue. But if the owner is coming in, it is imperative they at least try to listen to what they have to say. And in doing that, we're going to look more reasonable. I would also say do little things. What little things am I talking about? Postpone the hearing. If you set a hearing date and the owner says, I can't be there, especially if it's the first time, can postpone it. that I cannot tell you how many boards come to me and say, do we have to postpone it if they request it? Do you have to? No. Should you? I would say probably, yeah, at least the first time they request it, because again, what harm is it doing to us? Yeah, the violation still exists. Well, it was going to exist at the hearing anyway. Unless they cure it beforehand, it's still going to be there. Unless it is something very egregious, I cannot imagine an instance where it wouldn't be reasonable to postpone the hearing at least one time. The other part of that is when you enforce uniformly. If two owners have the same violation and it's a very similar set of facts, you should fine them or suspend their privileges to the same level. Now, I say that to say not every case is the same. Many cases are different. It's okay. I understand that. And we're going to talk about what to do there about differing enforcement here in a minute. Let me one more thing. Just don't go off that slide. It says enforce uniformly. Document why you choose not to enforce. Documentation is essential. If I have to go in front of a judge and I have a 5-page report on why a board chose to take certain action in a certain case, it is going to be a lot easier for me to defend than if I have to go into court and I have nothing but we found them in violation and a determination letter. If someone and documentation is key, especially where someone is saying that the board is selectively enforcing something. Selective enforcement meaning you're enforcing it in one case, same violation, not enforcing it in another. Obviously, that's a problem if that's occurring, but if you can, and this gets into the precedent discussion we'll have in a little bit in the next slide, or in the 2 slides from now. But if you document why you took the action you took, you will at least appear reasonable. If you're wrong, you're wrong. And the court will tell you that. But if at least you're reasonable in doing it, it may not be as bad as you think if you're wrong. So keep that in mind. You can go to the next slide. I put this slide in, and after I put it in, I questioned it. Please keep in mind, this is just a sample. I am not saying this is how you should find. This is just an example of, something internally that boards can use. Okay, for trash cans being out, for example, we'll adopt this schedule of $25 per week or $25 per day or a month, whatever you feel is appropriate. Understand that the higher the fine, the more the scrutiny down the line. So keep that in mind too. So this is an example. I am not saying you must adopt this. I'm not even saying that this is appropriate for your association. It's just an example of the categories, some of the categories you can see, and the schedule you may want to use as a guide. Okay. And the dreaded word precedent. I say it's dreaded. Us lawyers, we live by precedent. Whenever we do a legal opinion, we look at all the cases that come down because they're precedent on things. And many boards get thrown off track by the idea of precedent because we all think that if we did something in one case, we have to do it the exact same way in another case. That's what precedent is. And precedent in that sense to most people means uniformity. We've done it in the past under the same circumstances, so we have to do it here. And the key, of course, is, well, is it the same circumstance? Boards, when making decisions like this, may deviate from precedent. It's allowed. You just got to document why you're doing it. And is the reason you're deviating from precedent reasonable? You're held as board members to a reasonable person standard, considering all the facts and circumstances that you have before you when you're making a decision. That's called the business judgment. Okay. And in that light, if you decide to find someone in one case and not in another, if you can show what is different from one violation to the other, then it's okay to deviate from precedent. Again, and that courts do it all the time. We always get opinions from a court of appeals or a Supreme Court where this is the general rule, but we're not going to enforce it here because the facts are different. Same thing for a board. So the other key here is explain to the owner why it's different. It does no good to deviate and explain to yourselves why you deviated from prior action if you don't tell the owner why. Because the owner then is just wondering, it has that selective enforcement precedent mentality. And we want to get the owners off of that so that they understand why we're taking a different approach with this specific owner. So you want to make sure that you can explain the differences, because if you can't, and I kind of made a joke, the sheriff with the big black robe will rule against you, and that's true, because you're going to look arbitrary. You're going to look selective if you can't explain the difference. And that's the key. If you can't explain the difference between two incidences, and I'm just going to give you the example of parking on the street, or let's pick a different one. Leaving trash cans out overnight. One person left them out overnight, you fine them $10. Another did it the same time, $10. You did it the same. Third person did it, but you didn't fine them $10. You're going to be asked to explain why. Why is it different? Because otherwise it's going to look like you picked on these two people and not on that one. So if you can explain the difference, then it's probably okay to deviate from precedent. If you can't, then it's probably not. General rule there. So let's go on to the next slide. What if it's vague? The example in the mock hearing you just had was the grass height had to be a certain height. It was too tall. And the owner indicated, well, there's nothing in the restrictions about the grass height. Yeah, well, that's true. In fact, in one of the prior ones that we didn't submit in this recording, we actually used the word maintain. If anyone can tell me specifically what maintain means in a non-abstract, non-subjective way, please let me know, because I'd like to use it. Words like maintain, words like nuisance, words like unkempt, that type of language is open to interpretation, and it's going to be nearly impossible to enforce. Maybe not all the time, but there's precedent in North Carolina and South Carolina about that. So the 3 B's, I'm going to get into that. You got to make a decision. If you got someone let's use the yard maintenance example. You have to keep your yard well maintained. Well, what does that mean? It's vague, but you have to make a decision because you've got a yard that's got weeds all over it, grass that is a foot high, and an owner is just sitting out there on his front porch, not cutting it and not doing anything. What do? You got to make a decision. The first thing you can do is you can let it be. You cannot do anything. And as I stated a few slides back, if you do nothing, the owners can bring an action against this owner, but you could also face an action from other owners for breach of fiduciary duty because you're not enforcing the restrictions. You can advance a little bit there, Ben. You can let it be, you can bluff. Now, or you can be bold. And I don't want to explain what I mean by those. So as I indicated, you got to make decisions have to be made, and if you do nothing, you could face backlash from the owners and certainly lawsuits for breach of fiduciary duty. If you bluff, now why would you bluff? You would bluff the owner, and this works. I wouldn't put it in here if it didn't, but you have to use it in the right way. You can bluff the owner if you can try that if it is important to try to get compliance, but you don't want to push to the point of going to a lawsuit. You don't want to get sued. Having an owner in to discuss with them why they should keep their grass neat and tidy. Having a possibility of, hey, look, if you're having problem doing it, maybe our contractor can do it for you. Giving them options, but keeping in mind that, look, you've got to have your grass maintained. I mean, we live in a nice community. We want to keep it looking like that. That sort of bluff, and at some point you're going to have to say, and if you don't, we may have to fine you. That bluff has worked. It is not something that should be used lightly. It is not something that you should do without basis. But if you can't let it be, then you may have to bluff. If it's important enough, if it's a battle worth fighting, and the only people that know that are you and your members. Your attorney doesn't know if it's a battle worth fighting because he doesn't live in your community. You're the only ones that know that. If there's a legal basis for your enforcement, then stand your ground. It may result in going up to the Court of Appeals at some point, and that's okay if it's that important, but you're going to have to gauge that. You may lose, you may win, but being bold, being aggressive, holding your ground on things that are important makes you look reasonable because you've picked the important ones to fight, not the ones that are not so important, not the ones you could have bluffed on, not the ones maybe you should let be. For example, general nuisance language. You probably should let that be. So always understand too, the underlying crux of that. There is always the response to an owner who is complaining about another owner who is potentially in violation, that they can bring an action themselves. I want to give you an example of vagueness. I'm going to give you two example here and then the following one about enforcement and timely doing so. Steiner versus Windrow Estates HOA 2010 case. This is the Fred and Barney case. Many of you probably heard about this if you haven't. The Steiners are the plaintiffs. They lived in Charlotte. They had 2 goats on their property, Fred and Barney. They walked them with leashes, put sweaters on them. They treated them like pets. And the reason for that is Mrs. Steiner was sick. Her doctor's recommending having pets to help in recovery. I do not recall an argument that these were emotional support animals. If you're thinking along those lines, that argument was not made. And that may have been the end of this. It may not have gone that far, considering where we are with the Fair Housing Act. But nevertheless, the Steiners were, I believe, fined or were threatened to be fined and foreclosed on because they had the pets, and so they brought a lawsuit to seek an interpretation of whether they could keep the goats, that type of thing. The judge, the declaration itself prohibited livestock. Now, livestock wasn't defined. We know livestock was not horses, though, because the declaration specifically allowed for horses to be kept on the property, but livestock was not defined in the declaration. The court said that the estates, the HOA, could not take remedial action against these owners, and basically because of the following quote I put in there, that the law looks with disfavor upon covenants restricting the free use of property. Remember the general rule I stated way back 45 minutes ago. As a consequence, law declares that nothing that can be read into a restrictive covenant enlarging its meaning beyond what its language plainly and unmistakably reports. Livestock. The court interpreted livestock to be its plain meaning, whatever that is, and did not include goats who were walked on leashes and had sweaters. They were pets. And being pets, they could not be livestock. Therefore, the Windrow Estates HOA could not take remedial action against the Steiners. There's another case that I briefly touch on later. About interpretation of language. This is a war story that I was involved in. An HOA I represented is an air park. There's a runway going down the middle between the homes. There was a owner with a gravel driveway, not dissimilar to the one you have here. This is not the actual picture, but it's close. There was a lawsuit brought where I had to defend the association. They would not grant this owner a certificate of compliance, whatever that is. They would not agree that he was in compliance because he had this gravel driveway on his property. And the association said you didn't get architectural approval. We'll put that in there. It's an eyesore. We're not going to grant you compliance. Now, they had a hearing. They did not fine. I was not involved with them at that point, so I'm not sure why they didn't. So this owner brought a lawsuit alleging various things, but basically the big thing was that he was alleging that the association could not do anything to him regarding the gravel driveway, and it was in compliance because the gravel driveway had been there since 2003. Lord, just as you'll be aware, the Lawsuit was brought in 2017, so 14 years later. So all those years went by. The association was saying this owner was out of compliance because they had a gravel driveway on the road. Didn't take remedial action, didn't fine, and took no action. And then the owner wanted something that said he was in compliance. The association wouldn't give it to him, and so he brought a lawsuit. In the end, it cost the association $40,000. Would have cost the association $40,000 in legal fees if the insurance company hadn't paid him. It cost the owner who brought the lawsuit it was actually $45,000. And the result was this. After a 5-day jury trial, a jury found that this owner was in violation of the restrictive covenants because the restrictive covenants did not allow gravel driveways. However, they also said that the association should have taken action in 2003. Once they made that decision, the court said, fine, the association can take no action now. It waived its right. The statute of limitations ran, all those lovely arguments. What's the moral of that story? When you come, when a violation comes to light, you're going to take action on it, and you take action on it quickly. The longer it sits, the more opportunity there is for a statute to run, or there is an equitable argument called waiver. And I give you this example. Someone gets architectural approval to put a fence in their yard, and the fence is in the wrong spot, and it's open, and everybody sees where the fence is. Is it reasonable to wait 3 years to bring a lawsuit or to take remedial action against the owner to correct the fence? Probably not, because it's in the open like that. Everybody sees it. I would argue that a court probably is going to say the association waived its right to enforce it. On the other hand, if you find out it's in the wrong spot within, and you take action within a month or 6 months even, that's probably okay. You probably haven't waived anything yet. But the longer you go, the more chance you have to waive. So from the time of discovery is what the important date is there. In this case, with the gravel driveway, the time of discovery was actually 2003 because the gravel driveway was open for everybody to see. So we're about to go into the second mock hearing. This will not be near as entertaining as the last one, but hopefully it'll be an example for you on how these things can be conducted.
Wow, we have a lot of these hearings to get through, so, hi. Are you Callan?
Yes, that's me.
Hi, Callan. We're here for your hearing for the Stone Rock Hillcrest Meadows Pond Property Homeowners Association, Inc. Are you the owner of lot 2267?
Yes, I am.
Okay. Hi, I'm Chris Gelwicks. I'm the president of the association. Here with us also are 2 other board members, Dustin Kim and Kristen Farrell.
I'm really sorry that we have to be here today.
Well, I understand that, and thank you for that. We're going to discuss why we're here. So, you received a violation and hearing notice because we were informed as a board that you left your trash cans out and that your grass had gotten too long. Now, the management company sent you a violation letter, and when that was unanswered by you, we went ahead and sent this hearing notice.
Yes, and I want to explain what happened.
We would like to hear that as well.
All right, so as a board, okay, we have a duty to make sure that the members of the association adhere to the covenants. Relax, okay, this isn't a trial. It's just an informal hearing for us to determine if we should take any remedial action in the event that we find you in violation.
What would the remedial action be?
We can fine you up to $100 for each violation, and we can suspend your pool privileges.
And that's the maximum. Okay. But we really just want to get an idea of and hear what you have to say. Now, Section 8.2 of the covenants requires trash cans to be placed out of sight after trash pickup. Section 8.1 requires owners to maintain their yard. Okay. And now our rules committee adopted a rule that the grass can be no higher than 2.6 inches.
Wow, this is serious.
Well, we just want to hear what you have to say before we decide.
Well, you see, we had gone out of town to visit my mother who was in the hospital.
We are sorry to hear that. How is she?
She's much better. She's home now. It was an unplanned trip, and when we got back, we cut the grass immediately and pulled the trash cans inside.
We were informed of that.
By the way, where does it say in the restrictions that my grass can be no longer than 2.6 inches tall?
Well, Okay, as for the length of the grass, the purpose, as you can probably understand, is to make sure that the neighborhood looks neat and well kept and tidy and attractive. Now, our rules committee adopted that standard. Landscaping standards were sent out to the community.
Okay, I understand. I'm sorry about that.
And I don't believe that you have any prior violations of this nature.
No, I don't remember any.
Is there anything else you want to tell us?
It was one time and it's never happened again, and it didn't happen before. I've looked at the covenants too, and I really don't see anything about grass height.
Yeah, we understand that. All right, well, anything else? Otherwise, thanks for coming. We will notify you in writing of the decision. Okay?
Yes, thank you.
Thanks for coming.
Thank you.
She does have a point about the grass length.
Yeah.
And I agree, she has never done anything like this for.
Well, maybe this is one then where we find her in violation because of the trash cans and the grass, but we don't levy a penalty. I mean, she cured it when she got back. It never happened prior to this, and it hasn't happened since. What do you think?
I agree with that.
And I feel bad for her. I do think we should do that.
Okay, thanks. All right. So the sound quality wasn't the best there, so you couldn't hear. Basically, that was a more conciliatory hearing. Everybody was calm. We allowed the owner to speak. I wasn't shouting in her face. Nobody was yelling fryer or fine her to the max. The board members, at least from what I wanted to portray there, was they all listened to the owner and acknowledged what the owner did and acknowledged the owner's situation. Whether, I'm going to stop there for a second and say, whether you decide to take remedial action or not, if you can come across to that owner as you've listened to what they've had to say, even if you levy a fine or suspend privileges, it's going to be a lot easier on that owner. They will at least have believed they've been heard. In that first hearing, there's no way an owner would think I walked out of there and had their fair opportunity. So what was learned? We learned that by listening to the owner that these are isolated incidents. They'd never had any violations before. There was a reason because they had to go out of town on a family medical emergency. And the other thing here is, and there was some explanation of this about the grass cutting. They may be an issue with their covenants. The landscape committee in that case, in this, it was pointed out, adopted a standard of 2.6 inches for grass height, but that's not in the restrictions. And so it could be that there was an issue with publishing that. It could be that they want to consider adopting a community-wide standard in their covenants. There could be all kinds of things. But the real issue there was they listened to the owner. They listened that the owner did the research and look, hey, I don't know where this is in the restrictions. The board told her where it is. It was from a rules committee. So it was a conversation. It wasn't combative. And the question I have for the audience, I didn't put this in a poll, but was the board too conciliatory? Should have been more aggressive? And my thinking on that is it depends on the circumstance on how you want this to be. If the owner had come in with an attitude of I'm right, you're wrong, and this is wrong, you're not allowed to do this to me. It may be a time when we're a little more, to be a little more, not maybe aggressive, but just businesslike. That example that you just saw was more of a conversation. And really, board meetings are formal things, but when you're dealing with an owner and if I like to call it the nest where they live, and potentially finding and suspending privileges, the more conversational you can have these things, I think the better it is for everybody. And it's certainly going to look reasonable if court ends up coming later. So we can go on to the next one. Fun fact under the violations of rules there, or covenants and rules, in Spartanburg, South Carolina, eating watermelons in Magnolia Street Cemetery is forbidden. I actually had to look that one up and find out why, and that is because apparently when you're walking through Spartanburg and walk through that cemetery, a lot of people were doing it carrying watermelons. The watermelon seeds would fall to the ground and watermelon vines would grow up around the headstone. So
Again, interesting law, has nothing to do with HOA, but I thought y'all might, I thought it was fun. So for North Carolina, remember 47F and C. And if there's no process in place, a pre-fine suspension hearing is required. In South Carolina, absolutely. If you're going to have that in your documents in order for you to be able to do a fine suspension type hearing and take action. If you're coming to provide a process, remember that due process is favored. If you don't think your process is that good, you can't go wrong by following the statute. You got to make sure you communicate with the owners, explain why the fine is what it is, and explain the suspension process. If the fines are graduated, I do recommend publishing those because, if graduated fine meaning something like if the violation is not cured within 5 days, it's a $25 fine. If it goes another week, it goes to a $50 fine, and etc. That's graduated. That's the type of thing where you may want to publish that to the community so they can see what's going on, so they can see what they're in for. Certainly would put the graduated fine schedule in any determination notice that someone is in violation. Uniform enforcement is needed to avoid claims that the board is being arbitrary and capricious. Courts hate that, they do. You're not going to win if you come in there and if you're brought into court and it is portrayed that you were arbitrary, capricious, selective enforcement, no basis for the level of fine, no basis for the suspension. That's not going to be a very fun case. Self-help language, I addressed that. Understand it's in there. There's not much I'm going to say about that, except to say, if you intend to avail yourself of self-help, take all precautionary measures that you can. And finally, if it's vague, it's not enforceable. And that is, I talked about a slide about that, but there's also the Harrison versus Lands End of Emerald Isle case from 2010. For those of you who've heard me talk about that one before, that is the case where an owner down at the beach had let a swamp grow on the property. There was a restriction that required lots to be clean and sightly, not be a continuing nuisance, and be well maintained. Court, now this is an unreported opinion, but it still lends itself to discussion and heeding it. The court determined that that language was vague, open to more than one interpretation, and therefore unenforceable. So the moral there is you go back, if it's vague and you got to do something about it, you may have to bluff. And if you're going to bluff, please get with your attorney to discuss that. You can certainly call me and we can discuss that. So that's pretty much, that's the end of the formal presentation. And I'm sure we have a lot of questions. So we'll move to those.
We do have a few questions. Two precedent questions to start.
Okay.
One that has to do with a new board that has come in, and there's some old ARC issues that were approved by the prior board. There are only 5 items installed out of 204 units. Can we go about asking them to be removed?
You can always ask that something be removed. I mean, that's a request. That's not a demand. The issue that you face with action by prior boards and architectural approvals is you have a situation of what's called apparent or implied or actual authority. And you requested, the owner requested authority to install something or not install something and got approval. The association acted by its board and said, yes, you can do this. A board after that, I can't imagine a scenario where a board after that would be able to be able to force an owner to change what was already previously approved. I don't see a court requirement. And so you can always ask, and that may be the trick. To force them, they're going to be able to lean on the prior approval. And I really don't think there's going to be any chance that the court would agree with the HOA that they need to do even if it's a violation of restrictions. You may have to take other action against the prior board, frankly.
Okay. Challenges for enforcement when with a design guideline, such as a prohibition of rocks as ground cover. Now that almost 5% of homes have those, do we have to now allow rocks as ground cover?
I'm not sure I understand. 5% of those in the neighborhood, I guess.
I think the homes had not been enforced, or it hadn't been enforced for a while, and now that ground cover is
Gotcha.
Being rocks.
So the answer is the classic lawyer answer. It depends, but you're going to get into that waiver issue that I discussed a few slides ago. If a restriction is not enforced, and it just sits there, and then more owners decide, in this case, to have this type of ground cover with rocks. Over time, the neighborhood, the nature of the neighborhood is changing. So you're going to deal with at least one, a waiver argument, and two, it could be, I don't know, 5% is not a lot, but then I don't know the size of your community, so it's hard to say. But that could be enough to say that the nature of the community has changed to the point where that restriction is no longer enforceable, period. It's really a case-by-case thing. If you have 1,000 homes and 50 of them have this ground cover, is that a change? Has the nature of the neighborhood changed? I think that's a hard sell. At the same time, what about 200? That's closer. I know there's not a hard and fast rule. I think the bigger issue there is, if it wasn't enforced, if a number of years have gone by and there's no enforcement, I believe you're going to have a waiver problem.
Okay. Issue with an adjudicatory panel. Well, not an issue, but the adjudicatory panel has found an individual in violation, then fined, and the owner remedies the issue. Can they be fined again for future repeat violations without being called before the panel again? And does the notice need to state that?
I believe it was that they've cured the issue.
Correct.
Okay, that is the directly statutory. Now that's North Carolina. I'm assuming this is North Carolina. But South Carolina, it's still the same reasoning. Once the violation is cured, fining and suspension needs to cease, which is why, for example, continuing violations for trash cans, if they pull, if my trash can's out tonight, my trash pickup is today. If I don't pull it in by 8 o'clock tomorrow, technically I'm in violation. If I pull it in at 8 p.m. tomorrow and a violation was sent to me, have I cured it by pulling it in at 8 p.m.? Yes, I've cured the violation. So going to an architectural issue or something like that, on any issue really, once the violation is cured, your remedial action has to cease. There was a few years back discussion amongst those of us who practice in this area, the idea of, for example, the trash can issue. They keep putting it out. They keep leaving it out too long every week. Is that a continuing violation? I think that's a hard sell to a court, because the idea is the restriction says, you don't bring it in, you got to bring it in after pickup. Well, I left it out 2 days and then I brought it in. I've cured the violation. It's no longer in sight. So curing the violation means you got to start over. If they don't cure it and you've worded your notice of determination correctly that there's an ongoing fine once they don't cure, then you can continue to fine. Once it's cured, you got to stop. And I think there'd be much court backlash if you don't.
Okay, my community in North Carolina is a bit different situation. We have active covenants, but no established association. Enforcement has been sparse and non-existent for many years. Great decline has taken place. Attorneys have confirmed that the restrictive covenants are indeed enforceable, but we're having a hard time setting that into motion after time has passed with no enforcement. Prior violations should we say grandfathered? My question is how to establish a reasonable relationship with residents and prove this enforcement is not policing, but rather a protection for us all.
That's a tough one. Covenants that have gone on unenforced for a long time. Again, you deal with waiver issues, you deal with perhaps a changing nature of the neighborhood. If the current board is deciding we need to do something, we need to start enforcing these things, I recommend a procedure to my clients that are in that situation. As far as I know, it has not yet been challenged. And that procedure is that you send a communication out to the membership. And you indicate, here's what's happened in the past, but we are charged as a board with a fiduciary duty to enforce restrictions. Therefore, as of a set date, and I would say at least 90 days from the date of the communication, we are going to start enforcing these things, and we are going to enforce by way of hearing. We're going to send a violation letter first, and we're going to have hearings. If you don't cure the violation after the hearing, by the hearing, you could be fined. Will that work? I can't answer that. It's never been, that's not been before court, but I will tell you that looks more reasonable than just starting to do it. Putting people on notice of impending enforcement, with the basis of that pending enforcement being, we have the duty, the restrictions are here. I understand this hasn't been done in the past, but we're going to start now because it's what we have to do. You also, and you don't say it like this, but as being an owner in here, you signed up for this. That's reasonable. That's as reasonable as you can get. Giving people 90 days to get into compliance before you start enforcing in that situation looks reasonable in my opinion. Can I guarantee that a court won't strike it down? No. But I think you got a better shot doing it that way than just simply starting to enforce by sending out violation letters and having hearings. Giving people a start date with an adequate notice, I think, is a very reasonable thing, and that'll look really good if this gets challenged.
Okay, we have a marina with boat slips. Some of the boat owners do not properly secure their boats. If the HOA provides guidance on how to tie up their boats, then damage occurs that attributed to line failures. Is the HOA exposed to liability for making those recommendations? Or should the HOA address this through a violation policy and let the owners address it?
You faded out a little bit there, Ben. I couldn't hear all that. I'm sorry.
Oh, okay. Boat owners are not properly, they don't always secure their boats. If the HOA provides guidance on how to tie up their lines or tie up their boats, then damage occurs that may be attributed to line failures. Is this HOA exposed to liability for making the recommendation? If the HOA cures the poor boat lines, are we also exposed to that liability? Should this be done through a violation policy?
Okay, providing guidance on how to tie up a boat I do not believe is going to expose any HOA to liability. I guess if you're telling somebody to tie it like you tie a shoe, that's one thing, but I mean, if you provide guidance by telling everybody go to this video to see how to tie your boat, that's not going to expose you to liability. It's a recommendation on how to do it. If you cure the boat now, on the other hand, if the association goes out and avails itself to self-help and ties these things up and does it the wrong way and something gets damaged, could this HOA face liability? I guess it's possible. Yes, because what you've done is you've done something to alter something with someone else's personal property. You've done something to secure it, and it wasn't secured properly. At that point, there's probably a negligence argument that can be made against the association. So it's possible. My suggestion overall would be to send out reminders of tying their boats up properly, and that the association is not responsible for damage in the event the boat is damaged from not being tied up properly. And then provide access to some video on how to properly do it, perhaps.
Sorry, I started talking and hadn't muted, but Here's a question that may be answered two different ways depending on the type of property, but we have a non-smoking property. And if you have a homeowner that smokes inside their unit, can we take action against them?
Non-smoking property, meaning in the restrictions, it says non-smoking. If that's what it means, if that's what it is, then can you take action? What happens inside a unit, what happens inside a lot, courts are reticent to allow anyone to disrupt that. Short of illegal activity, to my knowledge, smoking if you're over 21 is not illegal, or is it 18, whatever it is. So I think that restriction would be difficult to enforce if it is a restriction. On the other hand, if you're in a common area, I have written rules for condominiums, for example, that you can't smoke in the common area, common elements. Same way for HOAs with common area. I've written those rules. The association in a planned community owns the common area. Unless the restriction says that the association cannot regulate smoking on the common area, then I believe it can, just like any owner of any property. The same is true for condominium common elements. However, inside a unit, inside the privacy of the home, I think it would be very difficult for a court to say we have that. Even if it's a restriction, I think a court would be very reticent to say the HOA can enforce that. Now, there's always exceptions. If you have people, I'm trying to think of a situation where you may have a building of perhaps full of, please don't take this, I'm saying this flippantly, full of lung cancer patients, then that may be different, but that's not really anything that's, I haven't seen anything like that. So the general rule would be what you do inside your house, inside your condominium unit is pretty much sacred.
Okay, so what action should be taken if the violations that have occurred are by a board member and not just a resident of the association?
It should be treated just like any other violation. The only difference is that board member should not be sitting in and being the arbiter of whether or not he's in violation. That board member needs to recuse themselves. If they don't recuse themselves, the vote that he or she cast should not be counted. I think it's okay to allow them to discuss, to deliberate, but that's going to happen anyway because you're going to call them into a hearing and you're going to hear what they have to say. But it needs to be treated just like anybody else.
Okay. How smart is it to resort to towing of vehicles as a solution to parking violations? Would a fine schedule be wiser?
Yes. Yes. How smart is it? In North Carolina, and I would say in South Carolina too, it isn't, in both states, I have seen restrictions that give the association the ability to tow from the common area. And I discourage the practice because of the liability that can be associated with it. If someone is parking in the wrong location, someone has an inoperable vehicle parked on common area, that's a different issue. But if they're parking in the wrong location, fine, you can have a hearing and fine. A fine, in my opinion, the court, let me just preface it like this. A court is going to look at the statutory remedies you have available to you. The main statutory remedy in North Carolina is a fine or a suspension of privileges. It's in the statute. They put it in there for a reason. They want you to use it. Even if the restrictions say you can tow, I am reticent to advise associations to do that. If it's an inoperable vehicle parked on common area, you don't know who owns it, you put out a notice who owns this vehicle, nobody owns up to it, different issue. Then maybe you can then you can tow it, I would say. But that's only after investigation, that's only after time. So how smart is it to resort to towing as a solution to parking violations? I would say it's not very smart. A fine is wiser.
Okay, you had commented earlier about rules and regulation violations subject to fines versus fining on declaration or covenant violations. Could you maybe further explain the reasoning behind rules and regulations versus covenants?
A rule or regulation, what I deem rule or regulations to be is, for an example would be your restrictions say pets must be leashed when they're not on the lot, but a rule would be when you're walking your dog, please pick up after them when they use the bathroom. Now, is that finable? Probably not, because it's not in your restrictions. If arguably, however, if your restrictions say that the association can adopt rules that allow over what happens on a lot outside of the residence, then arguably you could do it. That has not been, you could fine for that. Now, it has not been decided by the Court of Appeals of North Carolina Supreme Court or South Carolina Supreme Court for that matter, whether that type of enforcement for a rule violation is valid. Procedurally, it's the same. It's the same. You have to have a hearing before you levy a fine for a violation of a rule or regulation, just like you would for a violation of a covenant. The analysis is this: if your covenants allow the association board of directors to make rules that govern activity upon lots, then if I make a rule that says you can only do that, you can do certain things on lots, and you break that rule, it's the same analysis. You call it having the hearing, and it's really my argument would be you violated a rule that was validly passed because the restrictions allow you to make the rule. Do I think a court would uphold that? That's tough because it's not been heard. My preference is to have a restriction that says you got to clean up after your pet. If I don't have that restriction, what's the next thing? Well, what if they do it in a common area? Well, you can make a rule over the common area that says you must pick up after your pet if they go to the bathroom on common area. You own the common area. You can make that rule, and that certainly is finable after proper notice and hearing. So the question really is more on the lines of, is it on a private lot or not? If you're doing, if the violation of a rule is occurring on let's use another example, pools. You have pool rules. Well, those pool rules aren't in the restrictions. Are they enforceable by fine? Absolutely. Because the pool is on common area, and you have, as a board, have the authority to govern what happens on that common area. So you can make a rule, and you can make the remedial action pursuant to violation of that rule, fine or suspension.
So I'll clarify, let's say there is a restriction in your covenants that says all yards must be properly maintained, and then the board adopts a rule that says our definition of maintained is 2.5 inches tall grass. That 2.5 inches, you're saying, would not be enforceable.
That's where you're going to bluff, because the word maintain means different thing. If you have 100 people that ask what maintain means and you give them pictures, they're going to pick 80 different pictures. It's subjective. If you want to get that specific on enforcement and have it stick, the best way to do it is to amend your restrictions to allow either the architecture committee or the board of directors or landscape committee to adopt a community-wide standard. And then that standard adopted by the committee is published to the membership. Now that standard can have height 2.5 inches, but it shouldn't say things like you must edge your yard regularly. What does regularly mean? You're not curing the problem if you take that standard and make it vague. So the purpose of doing something like that is to be as specific as possible. Otherwise, if you're not going to amend your restrictions to go that route, then we go back to the situation of, it says maintain. I don't know what maintain means, but we have the standard throughout the community of 2.5 inches. We're going to bluff our way as long as we can. Hopefully you'll get compliance. There are some things where you won't. And that's unfortunate, but that's the way courts view language with restrictions.
So another clarification question. You had talked a little bit about if an owner cures the violation, you have to hold a hearing again. So we have a repeat offender. Let's say he's leaving his trash can out repeatedly. Every time he pulls his trash can back in, do we have to hold another hearing if it's left out again? So it's a repeat violation over and over. He's been held number of hearings. Do you have to hold a hearing again to fine?
Unfortunately, I'm going to say yes to that because every time he pulls it in, he's curing the violation. Again, there was a mode of thought, and you may get a different opinion from another attorney. That that is a repeat violation. I've actually seen some associations in their notice of termination say, if you cure it, fine, but if it happens again within the next 2 months, we're not going to hold a hearing. We're just going to levy another fine. I've never seen anything like that challenged. However, a strict reading of the statute, once it's cured, the violation stops. And so I would be hesitant to advise a client to do it that way.
You commented earlier about precedent, and so another example.
Ben, I can't hear you. I'm sorry.
Okay, you had commented earlier about precedent, and with an owner, we had an owner install a storm door. We had requested him to remove the storm door. But does the owner have to approve, the board have to approve future ARC request to install storm doors?
I'm looking for the question, Ben. I'm sorry you faded in and out. I apologize. I couldn't hear all of it.
Okay. Does the owner have to approve future ARC requests that ask to install storm doors, which are in violation of their covenants?
I see it. Does the owner have to approve future ARC requests that ask to install doors? I'm sorry, I'm not following the question. Maybe you can help me there.
Let's jump to another one. What if a person was chair of the architectural committee and got permission from that committee for something that is against the covenants?
Oh, okay.
Say a 6-foot fence where only a 4-foot fence is allowed.
Okay. Now you got a problem because the ARC is not supposed to approve things that are violation of the restrictions. So the first thing I would say is I need to ask this question. Is the 4-foot fence in the architectural guidelines or is it a restriction? Because that's a big difference. If the ARC, if it's a 4-foot fence and an architectural guideline and not a restriction, and they approve a 6-foot fence, a guideline is a guideline. That means it can be varied from. On the other hand, if it's a restriction and the ARC has approved it, a 6-foot fence in violation of restrictions, I would tell you that the board needs to get a new ARC in there. And depending upon the time that has passed, it may, I say may, be able to take remedial action, but it'll probably have to do it via lawsuit to get the owner to move it. The problem there, of course, goes back to what I said, and 10 minutes into this thing, once you, or I think the first round of questions, once there is an approval granted by an authority representing the association, it's going to be very difficult for the association to undo that. So, what I'm going to say is, you're going to face two situations in that case. One, all the owners are going to want to put a 6-foot fence up. And you're just going to have to go to those owners and say that was a mistake, but we can't do anything about it because we can't force the owner to remove it. That likely is going to be the scenario. But because it wasn't enforced, if it's a restriction and if it wasn't enforced in that case, you should still enforce it every other way. What you have there probably is the architecture committee being arbitrary in the other direction. They actually approved something without reason. They just did it. On the other hand, if the architecture committee says, well, we approved it for a specific reason and it's reasonable, it may be upheld. The issue there, again, there are a lot of issues in this. Is there a right to vary? Is there a variance restriction that the ARC has that power to differ from the restrictions? I don't know. I would need to read the restrictions on that. So I'm not sure I'm giving a very good answer there because it's a very fact-specific situation. Why did they approve it? Was it a guideline or a restriction? Is there a variance ability? In the end, I can't even tell you that the architectural committee is the final say on it. Some documents, some restrictions require the architectural committee to submit a proposal to approve or disapprove something and then submit it to the board for the final say. Others give architectural committee final approval. So there's a lot of interplay there. If that owner wants to email me, I'll see if I can help her out. On the next slide, I have my email that certainly send that out.
Okay, I'm going to do, I think, three more questions.
Okay.
So stormwater, now you could probably do a whole presentation on stormwater, but our development has a number of drainage swales that run through our neighbor's property. There are easements on these properties. Is it the HOA's responsibility to maintain these drainage swales? Do the homeowners have responsibility if they have erosion issues on their property that are contributing to the drainage swale requiring regular maintenance? How should this be addressed?
Yeah, we need a seminar on that one, but I'll do my best in a limited time here. So what we got here is this issue. First of all, there's easements. There's easements for stormwater runoff. We don't know who the easements are in favor of. Is it in favor of the HOA, meaning the HOA has to maintain the drainage swales? Or is it in favor of a utility? Or is it just an easement where runoff is to run? It was put in there by the developer and that's where it all goes and the documents are silent. I don't know. I see a lot of documents with these types of easements in them and the HOA is not responsible. So the question is the HOA's responsibility to maintain the drainage swales? If the easement is in favor of the association, meaning the association is the one that is granted the easement for the purpose of maintaining the drainage stormwater runoff, then yes, it would be. The level of maintenance, not the question that was asked. That's a whole different issue. As long as things are working properly, that's probably all that's required. Do the homeowners have a responsibility to, if they have erosion issues that are contributing? Okay. The second issue is if a homeowner is doing something negligently on their property that is causing the association to incur an expense, there is remedy for that, both statutorily and potentially in your restrictions. If the association, due to a homeowner's negligence, incurs an expense, 47F 3-115, I don't know which subsection, allows the association to potentially recover that cost. Since this is a violation section presentation, is that something that's finable? If you put someone on notice that their runoff is causing the association to have to do repairs that it shouldn't have to do, that could be a violation. Yeah, it could be. So you may be able to take that action as well. On the other hand, if the association has no responsibility, has no maintenance responsibility on it, then the association certainly doesn't have the power to go in there and maintain anything and really isn't going to incur any expense. Do homeowners have a responsibility for their erosion issues? They may have a responsibility for runoff, that they alter the flow of water and when they're building on their lot or putting something on their lot, and the result of that altered water damages someone else's property. That's a cause of action in North Carolina, or it can be. A lot of fact-specific stuff there, and maybe we do that as one of our next presentations, Ben.
Yeah, so two questions. So if an owner continues to leave a pet off the leash, which is a violation of our covenants, however, they have their dog on a leash following the violation, is that considered resolved if they continue to leave their dog off the leash?
Okay. What you have is a situation where an owner is observed with the dog off a leash, off a lot, most likely off the lot. Okay, that's a violation. You call them in for the hearing, and they were observed on this date, this date, this date, this date. 4 separate dates. You call them into a hearing for all 4. You fine them $100 potentially. And since it was 4 separate occasions, and 4 different violations, can you find them all 4? I would say you could try to do that. Yeah, that'd probably be okay. However, this is the type of situation where it's cured probably when the dog goes inside, because he's not off the lead, or when he goes back on the lot. Has he cured the violation? Probably. So you're in a situation there of, yeah, you're probably going to need a hearing every time you see him. And the question then becomes, there's another area that I did not get into, and that is neighbor pressure. In a nice way, owners in this, like for something like this, neighbors certainly, if they want to live in harmony with each other, should be able to go to one another and say, hey, look, get your dog on a leash, please. You'd be surprised at how much success that gets you. So there is that too.
Okay, last question. There is a complaint about a homeowner's flag. Documents have no restrictions regarding flags. There is a restriction referencing that no signs or ornaments are allowed within or without written permission from the association. The restriction specifically mentions realtors, contractors, subcontractor signs, but can find no language regarding flags in the document specifically. Is this enforceable? Can we enforce flags?
You know, flags and signs. If this is North Carolina, and to some extent South Carolina too, and I'll address that separately. For North Carolina, both both signs and flags have been addressed in the Plan Community Act. Because they've been addressed, if your restrictions do not mention flags, the statute mentions flags, and they mention it for a reason. And the courts then, in my opinion, would look at flags and signs differently. They are 2 separate things. I would even argue that a flag is not an ornament. A flag is a flag, and the reason it's a flag is because the statute says, here's what a flag is. Here's what flags you can fly. Regardless of what your restrictions say. So in North Carolina, I'm going to say to you that that is likely not enforceable. You likely cannot take action based upon language in your documents about signs to enforce something about flags. South Carolina, they have a flag statute regarding when you can fly the American flag or an armed forces flag. I would argue again, since the legislature has recognized what a flag is, if you're in South Carolina and your documents address signs but not flags, then you're limited to signs. And keep in mind, courts are going to review your restrictions strictly. If nothing else, you bring a picture of a sign and a flag in, the court's going to say that's a flag, that's a sign, and if your restrictions don't restrict flags, you can't do anything.
Well, Chris, thank you for staying in with us.
Sure thing.
Almost an hour over of what we committed to originally, so we've had a number of questions. Thank you for everybody that has also stayed with us till the end. I think there are about 45 individuals remaining. So I do really appreciate y'all's time this evening, and hopefully we were able to get you a lot of good information about wearing the white hat. So please look out for our next webinar 1 month from, the 3rd Thursday of every month. So this recording will be posted on our website. So again, thank you and good night. Good night, Chris.
Thank you all. Thanks for having me.
Thank you.